in the box lordship which has been said
limitation
6 day limitation 6 दिन का लिमिटेशन का लॉर्डशिप उन्होंने लगाया है, परंतु मैंने ये ड्रॉप बॉक्स में लॉर्डशिप मैंने पिटीशन डाल दिया था, उसके बाद चेकिंग के समय 4 दिन उन्होंने एक्स्ट्रा ले लिया लॉर्डशिप. दैट इज द डिफॉल्ट.
For that you have to move an application.
I will move lordship ignoring default lordship.
Ignoring or condonation of delay.
Ignoring default lordship.
Sufficient cause with you.
Lordship, because lordship, it is not my fault.
This may be a sufficient cause for condonation of delay, not for ignoring. आप ये प्लीड करके कंडोन करा सकते हैं. This is sufficient cause with you. But how to ignore it?
And lordship, there are some defaults also lordship regarding court fees lordship. That may be lordship, hard lordship that. Regarding that lordship,
नोट कर लेना जी क्या है. It appears that it is not that case in which default can be ignored. At the most, sir, that may be a sufficient cause with you for condonation of delay. How court can ignore it?
I will move lordship application for condonation of delay lordship.
Move it.
Lordship, I will move lordship.
My lord, in the top of the list matter, I am appearing for respondent number 1, my lord. First time I have appeared, my lord. Only first time I have appeared, my lord, for respondent number 1. I am seeking only 10 days time argue for the matter, my lord.
No, my lord. Since my evidence has been closed, my lord.
And if I have no objection, if the proceeding is stayed, I have no objection. Only 10 days time first time I have appeared, and I have to go through the record. Only 10 days I am praying. If the proceeding is stayed,
whether cost has been paid. Cost was imposed on previous date. Cost was paid.
Not in this case, my lord. This is yesterday's matter when I request you.
So read the impugned order. Impugned order is dated.
It's dated. No, my right has been closed, my lord.
Sir, previous to that passing of that order, opportunity was given to you subject to payment of cost of rupees 500. Read the order.
Page 15 is the order.
16.
Page 16.
Read it. These are the dates given to you. वादी शख्स हेतु समय प्रदान किया गया है.
On the 16.
अंतिम अवसर के साथ 500 रुपए करीब है.
Well, last date before the order, before this order was passed, before that 500 was imposed.
Whether that was deposited or not.
No, on that date, man, that is what I'm saying. That on this date, when the court closed my evidence, I went to the court.
With 500 rupees or not?
Well,
that 500 was ordered on the previous date.
But then, man, that is what I'm saying. I informed the court that.
The question is, in the event of non-depository of course, you are not entitled to any discretion. This is my personal view. I have already taken it on the basis of full bench of Punjab and Haryana High Court. Non-payment of cost.
No, Malad, I'm prepared to pay any cost.
Not now, sir. Question is, this cost was imposed on 16/8/2023.
But then the case was not taken. In my presence, case
was taken up thereafter on 6/9/2023, the day on which this impugned order was passed.
6/9/23, the case was taken, my lord.
But you did not pay cost on that day. You simply attended the court and informed the court and went away from that. You did not pay the cost.
That I
and then see my order based on division bench of Delhi and full bench of Punjab.
But still, what I'm requesting.
Non-payment of cost will forfeit your right to contest anymore. And that date has gone. You did not pay cost. निकला ना अपना एक Sri Prakash versus.
Yes, sir. But then I cannot.
I can give you my own view.
I cannot be penalized.
I am bound by my own judgment.
But
my view is based on.
Still, I cannot be penalized.
Can be, sir. 35B CPC.
Then that is what I am saying.
And that is mandatory.
But
it is mandatory to strike off your further defense.
No, I am not defendant in this case, my lord. I am plaintiff in this case.
Defending your right to contest, sir.
So, my lord, my right to lead evidence has been closed. Now, entire evidence, my lord,
Question is,
your lordship,
your right to lead evidence
My
is
lord,
clause. And on previous date, a cost was imposed and you did not pay the cost. You can't lead any evidence thereafter.
My lord, your lordship, may kindly see my right to examine an expert. It was fixed for right to examine
Would have been granted provided cost was paid by you.
My lord, what I'm submitting is this: at the most, I am not entitled to examine an expert. That's all. But entire evidence cannot be closed. Well, why it was fixed for the
If you
evidence?
don't pay the cost, entire will go.
My lord, it was not fixed for.
Sir, at least I am bound by, I may be wrong in having that view. My view is based on full bench of our High Court and division bench of Delhi High Court. I may be wrong also. But wrongly, rightly, I have taken a particular view. At which I am bound by my own judgments.
Since 12 years, this
Sir,
is.
are you angry?
Yeah.
This is not sufficient.
This.
My lord, he
He is nobody, sir. I am hearing you only. नहीं मिला अंदर श्री प्रकाश वर्सेस 1980 full bench page 1 and division bench judgment of Delhi 2008
my lord, for non-payment of cost entire.
mandatory sir mandatory read 35B CPC once it is ordered it is both directory mandatory when it will become mandatory I read my order and in the first instance it is directory but once it is imposed then it will become mandatory. Precisely that is the view taken by the full bench, by the division bench, and by me also.
Well, I did not have occasion to pay the cost.
Yes, you attended the court on that day and you went away from
And
there.
where's my presence not recorded in the order sheet?
Your own pleading, sir.
But then
Your
that
own
is,
pleading that I informed the court and went away.
But
Your
then-
presence was not. Now you can't take U-turn now.
no.
Your sole argument is that you attended the court on that day.
Yes.
After informing the court because defendant lawyer was not there, you went away from there.
Yes.
Thereafter your presence was not marked. This is your case pleaded now.
Yes, I have read that.
Estoppel is not applicable for you.
No, I can understand. But
You can't have both ways.
But-
Now on being caught, you will say that my presence.
Still, my lord, your lordship, may kindly see, my lord, your lordship has inherent powers. Your lordship has inherent powers.
Not to ignore my own view.
No,
By way of
no,
powers.
I'm not saying your lordship should ignore the view. My lord, I'm saying your lordship has inherent powers to see that the person is not penalized for this because of me. If I get, like my client was not present in the court. He was not present.
Best course is to challenge my order. Then. Yeah.
Yes, my lord.
Best course would be to assail this order somewhere else. I am bound by own order.
This is the last court here. Now, the only court is the Supreme Court.
I will give you judgment based on some reasons.
No, I have not seen the judgment, my lord. If I
I can give you.
I have got the.
Hmm?
Teja Singh is the judgment.
Not one.
This one.
50 orders
Sorry.
at least.
or
This is the Mallard's order. Teja Singh.
Sri Anand Prakash versus Bharat Bhushan, 82 full bench, Then Manohar Singh versus D.S. Sharma, Delhi, and single bench judgment, Gurmeet Singh, Jagjit Singh. There are so many judgments, and view is, in the event of non-payment of cost on the urgent date, it is mandatory on the part of the court to disallow the prosecution of suit or defense, as the case may be. Though the award of cost to the aggrieved parties is discretionary, a discretion of the court in terms of section 35B, but once the discretion is exercised and amount of cost is imposed, then the same is not complied with by the defaulting party, then it shall become mandatory. End of the matter thereafter. This is the view taken by me based on full bench and division bench, so many judgments of different high courts. At least it will operate as estoppel for me to take a different view.
Yes, that is there.
I am bound by my own order. It is not one, on at least 50 cases I have decided on this issue.
It's better if I withdraw and move again the trial court. That will be much better rather than get an order on marriage here.
I am bound at.
But then I will face
I
problems.
was not knowing this fact, but once I saw this in the vernacular order,
Yes.
then I found that 500 rupees cost was imposed on previous date, and that was not paid by you. Till yesterday I was with you. But the change during preparation of the case.
So what is the remedy left, Manoj?
Nothing.
But then,
Supreme Court, sir. Indigo flight.
well, he won't be able to afford Supreme Court.
I am bound, sir. I am bound by my own order. Perusal of impugned order would show that.
Well, then I will withdraw. Manoj.
After arguing this.
Let the order be passed on merits.
Yes.
Yes. I am saying that
Sir,
35B would not preclude a party to prosecute the further proceedings if he is agreed to pay the cost.
yes, that is precisely the view. This was the question raised before the full bench.
I am arguing this, Malad, that will not.
Then unless and until that full bench is set aside, division bench judgment of Delhi High Court is set aside, and all my orders are set aside.
No, Malad. I am submitting my argument may kindly be noted, Malad. I am saying that the imposition of the cost on the previous date of hearing would not be a factor to preclude the
I will
party.
say so in the order.
If party is prepared to pay the cost,
You did not appear on that day.
then if party later on,
And went away from there.
इसमें फुल बेंच का डिसीजन पंजाब हरियाणा का कंसीडर करते हुए उसको माना नहीं गया।
ये देखिए, this MP High Court has not agreed with the lordship full bench decision.
Not agreed.
No, this is showing.
Show me.
It is, my lord, reported in 2003 volume 1 MPHT page 90.
Show me the judgment, sir. Full bench or single bench?
A single bench judgment.
Then I am also single bench.
No, but MP High
Different
Court
views.
two different. MP High Court is
My view may be anywhere.
no. Malad, if the MP High Court has taken a view and is conflict with the lordship views, the matter has to be referred to the larger bench.
At least, sir, if third bench can refer it. I myself is bound by my own view.
No, your lordship is also bound by the view taken by the MP High Court.
No single bench, I am not bound, sir.
Yes, single bench, your lordship is bound. Yes, your
Single
lordship.
bench, my own view is there already.
Malad, your lordship single bench view in conflict with the view of the MP High Court would require that
My view is prior in point of time.
No, my lord, it is a prior one. It is a prior decision.
How?
2002, my lord.
2002?
MP.
2003 volume 1 MPHT page 90.
You also bring. I will hear you in detail then.
But it
And
is,
so appears on behalf of.
On behalf of respondent number 1, my lord.
The learned counsel for the petition submits that non-payment of cost imposed on the previous date would not be sufficient to disallow the prosecution of suit or defense, as the case may be, in view of law laid down by this
Yes.
court in
2003 volume 1 MP High Court today.
That's page 9.
citation लिख देना जी एक बार 2003 so and so.
1 MP High Court
Counsel
High Court
for
today. Page
counsel
90.
for the petitioner would be obligated to address arguments with reference to Sri Anand Prakash versus Sri Bharat Bhushan Rai and another 1982 bracket 1 RCR rent 1 bracket full bench and Manohar Singh versus Sri D.S. Sharma and others 2007 bracket 26 RCR civil 798 Delhi division bench.
Well, then one thing more, if the other party has no objection. Other party has no objection to order should be set aside.
Who is having no objection?
Why? I suppose other party doesn't have any
He
objection.
is standing in front of you. You are putting words in his mouth, but he is not saying that he has no objection.
No, now we will argue on this. We will argue on this.
Arjun.
But then,
Any day, sir.
week, and your lordship may give the week commencing
Week commencing next week.
next week.
But after Holi, my lord.
क्यों क्या हो जाएगा होली में?
Next week, there is a function at my family, my lord.
What is the next date before the trial court?
22 of March, my lord.
Before 22 March.
My lord, one humble submission, my lord.
His evidence has been closed. Supposing defendant evidence is closed and suit will be decided on that very day
So if my lord makes
under order 17 rule 3 because he has no evidence.
No, I have given my plaintiff has been examined. Plaintiff has been,
And he
plaintiff has
gets
been
them
examined.
after only then.
any date of
Plaintiff has been examined. It's not that my entire evidence has been closed.
it,
My right to examine
but
expert
firstly-
has been closed with other evidence. But my only witness was
Firstly,
the expert. I was not examining any other witness.
so this suit is pending since 10 years, my lord. He is just
Right after only.
my lord. My lord.
Because my first time actually I came across this because this was never in my practice.
I have quoted my own order.
No, my lord, I never faced this situation. That is what I'm saying. It never came in my as a lawyer. Never came before me this point. So I mean, normally we take the payment and cost is the normal condition which happens.
35B,
yeah.
though it is a discretion, once it is imposed
Yes.
and non-payment is there, then it will become mandatory. See the language of 35B also. And that has been interpreted by the full bench. This was the precise question frame.
35B provides the word shall.
Shall.
Shall. That is what shall has to be construed either as
Shall has to be considered as mandatory.
it may be directory and mandatory both, my lord. It's
Yes, but
always.
wrongly, rightly, that has been interpreted.
Yes.
35B. Let's have.
Uh,
Cost for causing delay if on any date fixed for the hearing of a case, suit or for taking any steps therein, a party to the suit fails to take the step which he was required by or under this code to take, obtains adjournment, evidence, the court for the reasons to be recorded, make an order requiring such party, the court for reasons to be recorded, make any order requiring the party to pay the cost would, as would, in the opinion of the court, be reasonable, sufficient to reimburse the other party respect incurred by him. Payment of cost shall be the condition precedent. May I read for you? On that day following the date of such order shall be a condition precedent to the further prosecution of the suit or the defense.
Your lordship decision is mandatory, shall has to be construed as
It
mandatory.
has been held by the full bench, by the
As
division bench of
mandatory.
Delhi, mandatory.
But it can be directory also, my lord, so not always.
It can be directly also, and not from me, at least.
I will not lead the evidence. I am giving the words to my senior also that we will argue first. Then
Don't be party to such type of affairs,
No.
that I will not lead evidence.
no, means it at least first.
Why you will not lead evidence?
No,
Against the interest of your client?
sorry.
What type of concession you are giving to the
My lord,
league?
Sorry.
You will act against the interest of your client? By
No,
not leading
no,
evidence?
no, my lord. I'm saying on the 22nd of March, my lord. That's why I'm telling to my
I have agreed date, sir.
my lord.
Obliged.
My lord.
Yes.
My lords, this petition, my lords, I am challenging the impugned order annexure P3, whereby my application under order 17 rule 1 has been rejected. My lords, my application was that on that given day, my